Kerr versus Illinois. The facts of the case are as follows. Frederick Kerr was indicted, tried, and convicted in the criminal court of Cook County in its state for larceny. The indictment also included charges of embezzlement. As he was in Lima, Peru, the President of the United States issued his warrant in due form directed to Henry Julian as messenger to receive the defendant from the authorities of Peru upon a charge of larceny in compliance with the treaty between the United States and Peru on that subject. The said Julian, having the necessary papers with him, arrived in Lima but without presenting them to any officer of the Peruvian government or making any demand of that government for the surrender of Kerr, forcibly and with violence arrested him, placed him on board the United States vessels Essex in the harbor of Callao, kept him a close prisoner until the arrival of that vessel in Honolulu. On the 25th day of June 1883, Kerr was brought to Illinois. The counsel for the plaintiff averred that the court committed an error. By virtue of the treaty of extradition with Peru, the defendant acquired by his residence in that country a right of asylum, a right to be free from arrestation for the crime committed in Illinois, a positive right in him that he should only be forcibly removed from Peru to the state of Illinois in accordance with the provisions of the said treaty, and that this right is one which he can assert in the courts of the United States in all cases, whether the removal took place under proceedings sanctioned by the treaty or under proceedings which were in total disregard of the treaty, amounting to an unlawful and unauthorized kidnapping. The issue in this case is that whether or not a state could constitutionally try and convict a person after acquiring jurisdiction by force. The court ruled as follows. There's no language in this treaty that this country in the subject of extradition by which we are aware, which says in terms that a party fleeing from the United States to escape punishment for a crime becomes thereby entitled to an asylum in the country to which he has fled. Indeed, the absurdity of such a proposition would at once prevent the making of a treaty of that kind. The power of the court to try a person for a crime is not impaired by the fact that he had been brought within the court's jurisdiction by reason of forcible abduction. There is nothing in the law which permits a guilty person to escape because he was brought against his will.